have everyone here who needs to be here? Yep. Is everyone content to start? Are the interpreters there? Can you hear transcribers? You're all ready? Yep. Okay, then let's commence for this afternoon. Before we move to Mr. Berkowitz's testimony, let me just address the procedural issues that we spoke about this morning and one or two other matters. Just for sake of clarity, I'm not anticipating that there'll be any objection by either party, but just to confirm that ICSID will be posting on its website the daily videos that's going out on the webcasting now. I don't anticipate that there's going to be any difficulty with that, but just to inform you. The pleadings and associated material is being uploaded onto ICSID's website as we speak. That's quite a sort of pernickety job, so it's going to take a little bit of time. Just to confirm that we will not, or ICSID will not be posting the exhibits that were used during the course of the hearing on the website. Everything should be in the record. As regards the procedural issues in respect of the questions that we put this morning, we would like the questions to be responded to orally, please, in the course of your closing on Friday. As regards Mr. Cantor's questions, and I think there were two questions, the first two questions which raised issues of material in the record, we would like those replies to Mr. Cantor's questions, please, to be by reference to the material that is in the record, including in the course of the hearing this week, so not any extraneous material. So I think that's it in terms of the procedural and housekeeping issues. And with that, I think we move to the witness evidence, the testimony of Mr. Berkowitz. Is that right?
That's right, Mr. President. And Mr. Berkowitz, if you could come and take the witness seat.
Good afternoon, Mr. Berkowitz. Welcome. You have a witness declaration in front of you. I'd be grateful if you could read that, please.
I solemnly declare upon my honor and conscience that I shall speak the truth, the whole truth, and nothing but the truth.
Thank you, Mr. Berkowitz. Mr. Copa.
Thank you, Mr. Berkowitz. I just have four areas I want to ask you in chief for a few minutes. Firstly, if you could just outline how you originally came to Costa Rica and how you came to purchase the properties which are the subject of your claims in this proceedings. You need to press the button each time you...
Can you hear me? I originally came to Costa Rica in 1991 on a surf trip, and like many others, I fell in love with the country, and most particularly the Ticos, the people of the country. Very unique. I was very impressed on the genteel nature of the people and the focus on environmentalism. It felt like home. And so it was early on, I was one of the pioneers in Costa Rica, and I knew that this was a place that I wanted to return to.
How did you come to purchase the properties, just in general terms?
It was presented to me as an opportunity that somebody was in financial duress, and that would I be interested in taking a look at a property that seemingly was a bargain. And I responded yes, that I would be interested, and that's when I first looked at the property in Playa Grande.
Okay, now I'd like to take you next to just deal, because you've dealt with a lot of other things in your witness statement, but I'd like you to talk specifically about your meeting with Minister Rodriguez. Could you tell the panel, I think in the evidence that's in the spring of, why don't you tell the panel what happened at that meeting?
Well, I have done real estate investing in the past, and I wanted to vet out the risks. I was aware of an existing conflict between a decree from 1991 and a park law from 1995, and I sought legal advice to sort out really two things: the seeming conflict between the decree and the 95 law, and also there was a project to expand the park that my attorney explained to me that the folks that wanted to expand the park had stated that there's no terrestrial component existing in the park from the 95 law, so there was a project of law that was placed in line for consideration of Congress in order to expand the park, I believe 1,000 meters, which would have no doubt included a terrestrial portion rather large and have greatly adversely affected the purchase of the property, the potential purchase of the property. So I requested, I went right to the top, and I requested a meeting with Mr. Carlos Manuel Rodriguez, who at the time was the environmental minister. He had the office on the top floor. I remember going into the Menai building, and all I remember was I was told that he was an avid surfer. And having grown up as a surfer, I thought that perhaps we could share that experience. And when I walked into his office, he had pictures of he surfing large waves, and we spoke a little bit about where we'd surfed, and a very pleasant gentleman. I was clear with Don Carlos that this was a huge chunk for me in terms of the amount of money that I was considering spending, even though it was a bargain on the surface. For me, it was a lot of money. It was well over $1 million. And literally, it was half my life savings as a chiropractor. So I really wanted to know, pardon the expression, directly from the horse's mouth. I wanted to know what the position of the Pacheco administration was and what his position as environmental minister was on those two issues, on the seeming disparity between the 91 decree and the 95 law, and on his position on whether they favored the expansion of the park terrestrially. And I also asked him for if he could possibly give me an opinion in writing in order to base my decision. So his response to me was quite candid, and he told me that unfortunately Costa Rica did not have the funds to go through an expropriation, but what they wanted was they wanted a voluntary regimen of conservation, low density development, low illumination of the beach, and a complete respect for the sensitive ecosystem in and around the nesting grounds of the baulas. You're speaking my language. I'm trained in biology. My heart was in that place, and my intent was completely to develop. Let me backtrack for one moment. When I purchased the property, it was already subdivided into 24 large 2-acre parcels, which was perfect for me because what my plan was to create a very low density, highly respectful environmental community. We say in Spanish, ambientalmente amigable, environmentally friendly, and high end, and that would appeal to a very high-end buyer. And I ran that by him in terms of that his vision and my vision were compatible. And he told me that while he could not put in writing what he was communicating to me, that there would be something forthcoming within a short period of time from his ministry that would explain their position on both issues, on the 91-95 conflict and on whether or not they were in favor of the project, pending project to expand the park. Subsequent to that, there was a meeting in June, and he met with all the heads of his department as per his promise, and all the NGOs, the non-governmental organizations, and it was to discuss their position on the Las Balas Marine National Park and the expansion thereof and the conflict between the 91 and 95 law. He, during the course of the meeting, we actually got into specifics about talking about how much of a setback that he would like to see on my private property in order to build my dream home, which was in front of a surf break. And we had a tete-a-tete, and he, of course, wanted more meters, and I wanted so many meters. In the end, I agreed to have a voluntary setback of between 15 and 20 meters from the 50-meter line, which is the public zone, in order to build my house that I had every intent, and then with my environmental impact report, put it in writing, of completely, to the maximum that a human can, mitigate my impact on the environment on the Bala nesting grounds. Elonged eaves, vertical illumination, the use of a sewage treatment plant, an individual sewage treatment plant. I was prepared to do everything in my power to demonstrate in real ways that I am for the turtle and that we want to live in harmony with this sacred grounds. For me, it was a very positive factor that we were bordering a park and that the turtles laid their nest in front of our land. It was, to me, it was, I had already had inquiries from one Hollywood magnate to purchase the property. This is just the type of client that we had envisioned. So I'll leave it there. I apologize for being verbose, but I wanted to give the entire history of why I went to the minister, what my intentions were, and what I was of the impression when I left.
Okay, I'm not going to ask you any other questions about that meeting. There are some things you haven't spoken of in your answer that are in respect to the meeting in your witness statement. Do you confirm your witness statement in respect of the meeting and other matters?
Yes, my witness statement is truthful. But
now
there is one change that I would like to make on witness statement 3. May I?
Yes. What paragraph, sir?
Well, I need to find it first.
Oh, I mean,
on witness statement 3, there's something that says 1991.
if you go to paragraph 14.
Paragraph 14, thank you. It says mistake typo in the 91 law. It should say 95 law. And I just want a point of clarification in my statement that following sentence, when it says Deputy Williams, that doesn't refer to a law enforcement officer. Diputado in Spanish means congressperson, congresswoman in this case. So please interpret the word deputy as diputada, which means congresswoman, and not an officer of the law as it reads in English. Other than that, I'm comfortable with my witness statement.
And the final question, Mr. Berkowitz, is what's been your experience with the expropriation process affecting your lots?
I started off in Costa Rica wanting to do something very special, a a model community of low density, high quality, major measures taken to mitigate our impact on the environment and the sensitive nature of the area. And total good faith, and love Costa Rica, love the Costa Rican people, and love the Baulas, and wanted to be part of it. My experience feels, pardon the expression, feels very frustrating. I feel on a certain level I've been baited and switched. I feel like I was encouraged on the one hand to build a low density, responsible, uni-residential community respecting everything that Costa Rica asked of me. And on the other hand, I feel like I got slapped in the face and broadsided, surprised that Costa Rica, rather than pass a zoning regulation, which we were all willing to adhere to, decided that they wanted to expropriate our land and create a terrestrial portion of the park. Please understand that the turtles that nest in front of my property nest on the sand, and between the sand and my borderline there are these dense Madera negra trees and cornizuelo. Cornizuelo are plants, pardon me, with sticker bushes, and they have horrible ants that sting. And you wouldn't, I mean, you'd be very careful walking through it. No turtle would ever walk through it. So I fully understand the concept of illumination and was fully prepared in any way, shape, or form to live up to the mitigating promises that I'd made in my environmental impact report.
Those are my questions, and I think that's our time.
Mr. Alexandra?
Thank you. Thank you, Mr. President. Good afternoon, Mr.
Good
Berkowitz.
afternoon.
Mr. Berkowitz, you have a binder in front of you, and I'll be referring to documents in that binder. To start with, your 3 witness statements are there behind tabs 4, 5, and 6, respectively. And I'll be asking you to look at them from time to time, although not necessarily right now. Well, you can look at your first witness statement behind tab 4, paragraph 7. Where you say that you acquired a piece of property that comprised more than 17 hectares in early 2003. Do you see that?
Yes.
And is it correct, Mr. Berkowitz, that you acquired that property from a company called Corporación Hotelera Playa Tortuga?
Yes, that's correct.
And you acquired it as a general representative of a company called Rancho Ecológico Las Baulas, correct?
That is correct.
Okay. And then subsequently, in September 2003, you acquired, sorry, let me take a step back. So the property that you acquired in early 2003 included 8 B lots, B1, 2, 3, 4, 5, 6, 7, 8, correct?
That is correct.
Okay. And then in September 2003, lots B1, 3, 5, 6, 7, 8 were acquired from that company by you and your sons.
I believe that what happened in September of 2003 is that the properties were transferred from Rancho Ecológico into individual companies.
All right. Indirectly, you and your sons acquired those pieces of property through other companies.
At the time, to me,
To you.
exclusively. Okay. It was later that I transpassed over to my sons.
So let me then correct the question. So in you acquired on behalf of, sorry, I just want to make sure I don't mispronounce. In January of 2003, you acquired all the B lots, all 8 lots, on behalf of a company called Rancho Ecológico Las Baulas.
Yes,
And then in September, you acquired through another company, B135678, correct?
several other companies.
Several other companies,
Yes,
all controlled by you.
yes.
Thank you. And when you did that, you conducted due diligence, correct?
Could you be more clear, sir? When
you-
I transferred the second time or prior to the purchase?
I'm sorry. Let's talk about the purchase in early 2003. Before that, you conducted due diligence, correct?
To the best of my ability, yes.
Of course. And you actually have testified about that in your second witness statement, paragraph 11. That's behind tab 5. And you say there, you refer to your first witness statement and you say, quote, I conducted significant due diligence before deciding to purchase the B lots. You see that?
This is the same paragraph where I said I find the respondent's allegations offensive?
Yes.
Down below that?
Yes. The third
Yes, okay.
sentence. And again, I quote, I conducted significant due diligence before deciding to purchase the B lots.
Correct.
Okay. And is it correct that the conclusion of your significant due diligence was that the B lots were outside of the park?
That is a correct statement.
Okay. Well, and let's look, just to be clear what you've said about that. So let's look at paragraph 8 of your second witness statement, which is behind the same tab 5. And what you say there, last sentence on page 3, I purchased my property with the clear understanding that it fell outside of the park boundaries defined by the 95 law. Correct?
That's an accurate statement.
Okay. Let's look at paragraph 10, just below. Somewhere in the middle, well, the 6th line at the end, the word the 95 law, as written, did not include any of my property. Do you see that sentence?
Yes.
And that was the conclusion you reached as a result of your due diligence, correct?
Yes, sir.
Let's look at paragraph 13 of the same witness statement. And you say there, and I quote, at the time I purchased my property, there was no doubt surrounding the boundaries of the park. Do you see that?
Yes.
You maintain that statement?
I had no doubt.
Okay.
I would like to say I had no doubt surrounding the boundaries of the park. I've already testified that, in fact, as part and parcel of doing my due diligence, there was a doubt that existed, but after conducting my due diligence, I had no doubt.
So to better understand the correction, you had no doubt, but other people you established did have doubts about the boundary of the park. Is that your testimony today?
That's correct.
Okay. Well, Mr. Berkowitz, we will go through a number of documents that I think will illuminate for us your state of mind at the time. Let's start with tab 37. actually, again, the same exercise as we went through with Mr. Reddy. You will have behind tab 36, Spanish document, and behind tab 37, an English translation of the stamp. For the record, this is Exhibit C23A. Please refer first to the registry drawing, which is behind tab 36. And my first question is this a registry drawing for lot B1?
I'm sorry, I don't have my reading glasses, and so I can't read the name that's on this plano. Could somebody tell me the name that's on this plano
Well,
that we're referring to? You're asking me to identify
Right.
it, and I'm very sorry, but I can't read this.
Do you want to get your reading glasses?
well, if the witness cannot read the documents, we have a problem.
All I need is a pair of reading glasses.
Do you have those glasses there?
This plan is not independently identified as Lot B1, so it would be identified by name.
No, it won't be, I submit to you. The
No?
B1 would not be on that plan. But I'm asking
Thank you.
if you can use the glasses to look at the
Much
document
better.
and tell me whether you recognize this registry drawing as the registry drawing for lot B1.
Yes, it does have a name on it. Aceituno Mar Vista Estates.
Oh, that's the name
So
of-
yes, as such, I do recognize it as B1.
Okay, so it is B1. So let's look at the stamps that we have translated in English behind tab 37. And I ask you to start with the second stamp, which is on the back of the page, because I want to do that chronologically. It's a stamp of the Ministry of the Environment and Energy, that is MINAE. Do you see that stamp, Mr. Berkowitz?
Yes,
The date is September 9, 2002, correct?
correct.
And the stamp says that the property is approximately 40% inside the park. And to avoid a lengthy discussion, it refers to the 1991 decree, correct?
That's what the stamp says, yes.
When did you first see this stamp?
Late 2002, early 2003?
It was before you purchased the B lots.
Yes,
And you saw that the view of Minai at the time was that 40% of the property was inside of the park based on the 91 decree, correct?
I saw the stamp.
And that stamp
I
did,
cannot independently corroborate whether Minai was of the view that it was in the park. As far as the intimacies of the decree in 1991, my attorney informed me that in that decree, it said in the decree itself that no lands would be part of the park until they were expropriated.
well, Mr. Berkowitz, I'm not asking you
So
to.
I cannot independently corroborate whether Minai was of the opinion that it was legally a park or not.
That's not my question, Mr. Berkowitz. My question is the following. You have testified, as we established a moment ago, that you had no doubt that your property was outside of the park. And I'm asking you, when you saw this stamp before you purchased the property, did that stamp introduce any doubt in your mind?
None whatsoever.
Could you look at the first stamp on the first page? It's a stamp of Minai too, isn't it?
Yes?
The date is May 13, 2005, correct?
Yes?
It says that the property described is located inside Las Baulas National Marine Park, correct?
That's what it says?
And it says, according to Executive Decree of July 9, 1991, and Law 7524 of August 16, 1995, correct?
That's what it states.
So, at least on May 2005, the Minai stamp indicates that the basis for Minai's determination that the property was inside of the park was both the decree and the law. Is that what the stamp says?
That is what the stamp says.
When did you first see the stamp?
Considerable time after that. I cannot remember when.
Approximately?
Sometime later in 2005.
And when you saw the stamp later in 2005, you still had no doubt whatsoever that your property was outside of the park?
This stamp, in my mind, shows that Minai was of the opinion that it was in the park. That was not my opinion.
I understand that. You had an opinion that your property was outside of the park. Minai, as we just established, had an opinion that the property was inside of the park, both on the basis of the decree and the law. And my question is, whenever you saw that stamp in late 2005, did that introduce any doubt in your mind that your property might be inside of the park?
It's the same issue as that came up, will come up over and over again, is that my attorney informed me that I had sacrosanct property rights until I was paid for my property, that I maintained full usufructo and pleno dominio over my property until such time as I was paid. I had a high level of certainty that Costa Rica would act in good faith, and that in fact, in their wisdom, if they wanted the property, it was fully within their right to take the property, providing they paid me a reasonable amount of recompense, indemnification, in a reasonable amount of time.
You may be right, Mr. Berkowitz, that we'll come to that point, but we're not at that point yet. Right now, we're talking about whether the property is inside or outside of the park. So that was my question. Let's look at the next property. If you turn to tab 40, and now we have this time in tab 40 both the full Spanish document and the English translation of the stamp. So if you look at the registry drawing, I'd like you to confirm, if you could, that this relates to lot B3.
Where might I find the plan here?
I'm sorry, tab 40.
I'm in tab 40.
Okay, there is a blue sheet in between. After the blue sheet, you will see the plan. Propiedad de Guasimo Mar Vista Estates.
The plan that I see here, sir, is 2,736 meters. That is not the size of Guasimo Mar Vista Estates. I did not, this is not one of my plans.
It is not?
No. I did not make this plan. This plan was made, I believe, by Minai. It measures 2,736. All of my properties measured at least 7,000 meters.
Well, if you look below, area registro, it says 7,101 7 square meters.
I did not make this plan.
Well, regardless of who made this plan, is it a registry drawing of property B3?
It looks to be part of B3, but it certainly isn't the plan B3 that I purchased.
Well, we'll have to go through an exercise then to establish that this is B3. It will take some time, but we'll have to do it.
As I said, it's part of it looks to be the westernmost part of B3, but it's not the property that I purchased. I didn't make this plan.
I take your testimony you didn't make it.
Okay.
It covers, you say, part of B3.
Yes,
Okay, and the westernmost part of B3.
yes,
And is that the part that is closer to the sea?
yes.
Okay, well, I think that's sufficient. We can go through the exercise of establishing that because we have the documents, but I think that's sufficient for present purposes because if you look at the stamps say that that property that is reflected on this registry drawing, and that's part of your B3 property, is inside of the park. So let's look at the second stamp first, which is dated September 2002. It's on the right-hand side. Do you see that? That's the
Yes,
stamp
I
of
do.
Minai. Yes? I'm sorry, do you see that, Mr. Burke?
Yes,
You see the date September 9, 2002?
yes. What plan does this relate to, sir?
That, the same one that is behind that tab. We have
This
just,
plan relates to the Guasimo Mar Vista plan, which is 7,000 meters, or the 2,700. I believe this stamp existed on the Guasimo Mar Vista plan, which I don't see here in its entirety. This was the stamp that was on that plan. This stamp, I believe, is the stamp that is on the abbreviated plan that I did not make. So since we're on the record, I want to be very accurate.
well,
I'm not trying to be difficult.
No.
I want to, for purposes of being accurate, I want to be completely clear that this stamp that you show me in September 12, 2002 existed on my original Guasimo Mar Vista plan, which measured in excess of 7,000 meters.
okay. Well, please turn to the second part of the document. If you go to the plan,
Yes?
leave the stamp. We need to clear this first before we go to the stamp. So go to the Spanish language document first.
The 2,736 meter
Well,
plan.
let us do this. There is at the left hand side bottom corner of the drawing a number 13101. Do you see that?
Yes,
Okay, so that we established is the western part of B3.
yes,
Okay, if you look further 2 pages,
yes,
you will see a registry drawing that says property of Corporación Hoteliera Playa Tortuga.
yes,
And if you see somewhere right in the center of the document, just below the drawing, there is a date 26 September 2003 that says Hoy de Guasimo Mar Vista Estates. Do you
Yes,
see? So
I agree.
today, it is the same owner that we see on the first registry, correct?
This is my original plan, yes,
Okay. And it is for the 7,000 meters.
yes,
Okay. And it has a stamp of 9 September 2002.
yes, it does.
Okay. And that stamp, you can refer to the Spanish or the English, that stamp of 9 September 2002 is a stamp of Minai, correct?
Yes, it is.
And that stamp says that the property is located inside the park, correct?
That's what the stamp says, yes.
Approximately 45%. Yes?
Yes, that's what the stamp says.
And it refers to the 1991 decree, correct?
Yes,
Okay. And then we established that on a drawing of part of B3 property, that is the part that is closest to the water. We have a 2005 stamp of Minae, dated May 13, 2005. Do you see that stamp?
Yes.
It doesn't give the percentage because it's part of the property now. It just says the property described is located inside the park. Do you see that?
Yes.
And it refers to the 1991 decree and the 1995 law. Do you see that?
Yes.
That did not introduce any doubt in your mind that the property might be inside of the park?
No. No, I did not believe at that time, after consulting with my attorneys, that the process that was in the process of creating an expansion of the park, I was of the opinion, as a result of consulting with counsel, that this would not come to fruition.
So is it your testimony that you consulted with your lawyer after you saw the stamp and requested an opinion from your lawyer about the significance of the stamp?
Correct.
Did you share,
That is correct.
and you obtained an opinion from your lawyer in Costa Rica?
Several lawyers,
In writing?
not to my recall.
So it was an oral discussion.
Yes.
And the conclusion of that discussion was the stamp does nothing to create any doubt that your property might be in the park.
For Manai's purposes, they are trying to show and signal that they are, would like to exercise their right as a sovereign country to expropriate property. That's what it shows, that they are in the process of an expropriation process. But I was also told that until I am paid, that expropriation is not complete. And so I was told by my attorneys that this is something for Manai's purpose. There's a stamp showing they would like this to be part of the park. For my purpose, in terms of as an investor, I thought I was told that was premature.
Well, those are two different points. So first, the Minai stamp seems to indicate not that they would like to think this is inside of the park, but they do think it's inside of the park, which you confirmed. But I think you didn't address my question. My question was different. It was not about whether the property would be expropriated, and if it is expropriated, you would be paid compensation, and that's what you expected. The question goes to a much narrower point, which is whether the property was in the park or not. If your lawyer told you that the property might be expropriated, but if it would be expropriated, you would receive compensation, that would suggest that the property is inside of the park, doesn't it?
Quite the contrary. My attorney informed me that in Costa Rica, according to the laws of expropriation, that the property title did not transfer until the expropriation came to completion, until I was paid.
Mr. Berkowitz, I apologize that I insist on that, but I'm confused. If you had no doubt this property was outside of the park, why would the subject of expropriation arise in the first place? It would not be subject to expropriation, isn't that correct?
Because there were notices of expropriation. It was clearly signaled by the Costa Rican government that they were preparing to start an expropriation process. It was no secret.
On the basis of the Costa Rican government's understanding that those properties were inside of the park, correct?
On the basis of Costa Rican law, which is the Costa Rica law of expropriation.
Well, the Costa Rican law of expropriation is a general law, but the properties inside of the park were subject to expropriation based on the law of 1995. Isn't that correct?
They were subject to expropriation. I'm not arguing that.
Okay, but You understood that they were subject to expropriation based.
Absolutely, Costa Rica has every sovereign right to expropriate that property.
I'm sorry, you have to wait for me to finish my
Sorry.
question. They were subject to expropriation under law 90 of 1995, correct?
That's a legal question that I cannot answer.
Well, I'm asked, I thought, I agree with you, but I thought you testified that your understanding was that the property was subject to expropriation. You actually stated a legal opinion that that would be under Costa Rican law of expropriation in general. And I'm asking whether it is not correct that the property in that area was being expropriated because it was the government's understanding that it was inside of the park.
It's a fine line, sir, between what my recollection of what my attorneys advised me and me trying to give or cite Costa Rican law, which I'm not qualified to do. So you're asking me to, I believe you're asking me to interpret Costa Rica law, which I'm not qualified to do.
No,
I have testified what my attorneys told me and what my understanding was to the best of my ability.
What I'm trying to establish, Mr. Berkowitz, is not your legal view, because you're not a lawyer, and we understand that. What I'm trying to establish is this. You have seen stamps that say the property is inside of the park based on the decree and the law. You have seen expropriations, or at least the initiation of expropriation procedures, and you're still testifying that there was no doubt in your mind that your property was outside of the park. And I'm trying to reconcile your understanding, your conviction, without any doubt that your property was outside of the park, with the facts of which you are aware that Minai's view was that your property was inside of the park and that expropriation procedures had already been initiated. And I'm submitting to you that it seems difficult to agree with a statement that you had absolutely no doubt that your property was outside of the park, with your knowledge that property as yours was being expropriated and that Minai had taken a position that it was inside of the park.
I agree with almost everything that you said, with the exception of the very last sentence, which is that I am stating that I agree that my property was inside the park. I agree that Minai was signaling to expropriate. I agree that they have the right to proceed to expropriate. I agree that I was informed that this process was starting, but you're asking me to state something that I'm unwilling to state, which is I did not believe at that time that my property was inside the park. I cannot say something that I don't believe.
And when you say at that time, you mean what time?
The time that you're referring to here, when you're asking me to read these plans.
Well, I'm referring to
The date on these stamps.
Well, I'm referring to stamps in 2002 and 2005. So let me ask you, in 2002, did you believe your property was inside of the park?
No.
In 2005, did you believe that your property was inside of the park?
No.
When did you come to believe that your property was inside of the park?
My belief is that the property will be inside the park at the completion of the expropriation process, when I'm paid.
Well, okay. You're now making a legal distinction, so we need
I am not qualified to do so, sir, and I apologize. You asked me my belief.
Right.
That's my belief.
Let me probe that further. Technically, your property is not part of the park until it is expropriated and the government owns it. And that is something that I represent to you. The question is whether your property is within the boundaries of the park. So let me restate my question to avoid the legal discussion. Did you believe in 2002 that your property was within the boundaries of the park?
No.
Did you believe in 2005 that your property was within the boundaries of the park?
No.
When did you come to believe that your property was within the boundaries of the park?
I'm still waiting to be paid in order to be expropriated, and at that point, the property will be within the boundaries of the park.
Okay. Mr. Berkowitz, we went through lots B1 and B3. I represent to you that we have the exact same situation with respect to the registry drawings, with respect to lots B5, 6, 7, and 8. We have the exact same stamp in 2002 referring to the 91 decree, and the exact same stamp of Minai of 2005 referring to both the law and the decree. Would you accept that, or would you like to review all those documents?
It's not necessary, sir, and again, I'm not trying to be difficult, I'm giving you my true belief.
No, I'm not asking
And
you
it
this.
would be the same for each one of those properties.
I'm not asking about your belief. I'm asking you, would you accept my representation that the exact same two stamps appear on the registry drawings of the other B lots, 5, 6, 7, 8?
Yes, I would.
Okay. That makes it unnecessary to go through the same exercise with respect to each lot, and I appreciate your cooperation in saving some time, which allows me to go to another document. Could you look at tab 59? There is, this is a document in Spanish behind the blue sheet, and a partial translation in English. For the record, this is Exhibit R16. And this is a Minai resolution of June 2003. And it's addressed to you, Mr. Berkowitz, in response to a formal application you made to Minai. If you look at the very first paragraph, it says first in English. In Spanish it says primero. If you're looking at the Spanish, it says that on March 24, 2003, you filed a formal application seeking a permit for the felling and pruning of 74 trees. Do you see that?
Yes.
And we have in second, number 3, the description of the property certification. So I will represent to you that this includes lots B, 1, 3, 6, and 7. Is that correct? Would you agree with that?
I recognize this permit, and it is quite familiar to me. So I would agree with that.
Okay. Well, let us look at, in Spanish it's page 7. In English it is the last page of the translation. Are you looking at the English?
Yes.
Okay. Where it says 5, it says to comply with the provisions of Executive Decree number 2518 of July 9, 1991, and of Law 7524 of August 16, 1995, where the Las Baulas Marine National Park and the protective area include an area of 125 meters of land from the ordinary high tide line. Do you see that language?
Yes, I see that.
So then, Mr. Berkowitz, isn't it correct that in response to your formal application to MINAI in March of 2003, MINAI issued a resolution in June of 2003, and in that resolution relating to the felling and pruning of trees, it also stated that the Las Baulas Park, under Decree of 91 and Law of 95, extends 125 meters inland from the high tide. Is that what MINAI said in that resolution
Yes,
addressed
that's
to
what
you?
they said.
I'm sorry, you have to wait for
I'm
me
sorry.
to finish the question. Is that what the resolution that was addressed to you said?
As you stated, that is what it said.
In June of 2003, when you saw this resolution, did that introduce any doubt in your mind that the B properties were inside of the park?
Sir, I'm not sure about the timing of the National Geographic Society of Costa Rica's study. In the course of going for my environmental permits and my environmental impact report, and I was asked as part and parcel, as I think Mr. Reddy testified, to have a pronunciation for water and building permit and whether or not my property was inside or outside of the Baulas National Park. And somewhere around that date, the National Geographic Association came out with an official decree that my property was outside, completely outside the boundaries of the Las Baulas Marine National Park.
We'll get to the National Geographic Institute.
So I had doubt seated in my mind from official documents, and I don't remember the interplay of the dates.
Okay, well.
So this is in June. Somewhere around that time, this came in. You're asking me, please repeat your question, I'm sorry.
Well, turn to the last page of the Spanish document. There is a stamp.
What page?
The very last page of that document, the Spanish document. The very last page is behind tab 59. The very last page.
Yes, I believe I'm on the page.
Very last page.
Uh-huh.
Please keep turning the pages. The very last page, Mr. Berkowitz. There is a stamp. Your name, having received this document, and it says June 2003. Do you see that?
Yes?
Okay, so you received this document in June 2003. It was addressed to you. And I'm asking you now about this document, which was an official resolution of MINAI in response to your formal application. And this official resolution states quite explicitly that the Las Baulas Marine National Park extends 125 meters of land from the ordinary high tide. And I'm asking you, when you saw this resolution in June of 2003, did it create any doubt in your mind that your property might be inside of the park?
It's the same answer, no, it did not.
You testified in your witness statements and in direct examination that around that time you went and saw Minister Carlos Rodriguez, correct?
Correct.
And you testified that he told you that the government was willing to avoid expropriation and impose strict regulation of the properties in the area, correct?
That is correct.
Did he tell you that his belief was that the park did not extend towards the land?
Sir, in the meeting, I was very clear that I want to build my home in front of this surf break, which existed within the 75-meter line. It was very clear, and the answer is that we want to see a low-density development that's respectful of the baulas, and we were talking, as I described, how far of a setback from the 50-meter line, and I certainly was told by my attorney that if that was park, that there would be no way that I could build within the 75-meter line and have to go through an entire environmental impact report, which was extensive, a large book. It took me a year, tens of thousands of dollars, if I did not have the right to build within that. We were talking whether it was going to be 15 meters or 30 meters, but in any event, it was within this 75-meter strip that was in dispute. And if it was a national park, nobody could have given me any indication that I could have built there, no less the Minister of the Environment. So I was very much led to believe that I could go ahead and that I should go ahead with my environmental impact report, which, by the way, was preliminarily approved to build my house 20 meters from the ocean, from the 50-meter line, from the public zone. So to answer your question, again, I don't mean to be argumentative. I was very definitely given the impression that I could build 20 meters from my borderline as long as it was an environmentally responsible home. And I went and spent $30,000 preparing an environmental impact report. It went through Satana, who is the
Mr. Berkowitz, I'm sorry I have to interrupt you.
Okay.
And if you don't answer my questions, I'll have to seek instructions from the President of the Tribunal. No, you did not. Let me repeat my question, and please focus on the answer to the question. I was not asking you what you discussed with your attorney and what you believe was at the time of whether you can construct and where. I was asking you specifically, in your meeting with Minister Carlos Rodriguez, did he tell you that the park extended seawards from the high tide? Or did he tell you that the park extended inland from the high tide? Or did he tell you anything about this?
Yes, he did.
Did he tell you that the park extended seawards from the high tide line?
My recollection of what he told me was in the lands that are in dispute, the private zone of the lands of the 75 meters, that what they want is a co-management plan, a proper zoning to protect the turtles, where the owners of that property, in order for Costa Rica to avoid expropriation and the tremendous expense, what he wanted was a voluntary regimen of adhering to logical, very sensible mitigation factors to live in harmony with the sensitive environment around the turtles, and that by all means that we could build in that 75 meters zone.
You've testified in your witness statement, and you repeated that on direct, that Minister Rodriguez informed you that a directive would be forthcoming from MINAE as to the position of the government on the rights of private landholders in the 75-meter zone, correct? You remember that?
Yes, sir.
That directive never came, did it?
Pardon me?
That directive never came. Is that correct?
I don't understand your question. Are you asking me, was there ever anything in writing that came of that meeting? I don't understand.
Okay, let's look at paragraph 12 of your first witness statement behind tab 4. Paragraph 12 of your first witness statement, tab 4. The fourth line, he informed me, you testify, that a directive would be forthcoming from his ministry as to his administration's position in writing on the rights of the private land bordering the park immediately, following an upcoming meeting that he planned with his heads of department, etc. Do you see that? That's your
Yes.
testimony. And I'm asking you, did that directive in writing ever came?
Yes,
There was a directive in writing from Minai.
yes.
Can you point me to a document in the record that is?
It's called Ayuda de Memoria.
Well, the Ayuda de Memoria is the minutes of the meeting. It's not a directive, but when you say directive, you refer to those minutes, is that correct?
That is what I saw as he couldn't respond to me in writing. It would be immoral for him to give me a moral. I'm a single person just trying to build my home.
You testified about that. My question is
But
when
he told me there would be a directive forthcoming from his ministry that would make everything clear.
and
A
that
few weeks
directive is
later,
the
it
minutes? Is that directive the Ayuda Memoria?
Yes.
Okay, let's turn to that then.
I don't know where it is.
I will show you. It's tab 54. For the record, it's Exhibit C53. We have English and Spanish. Is that the document you're referring to as the directive in writing?
Yes.
Okay, well, I'll be referring to the English. You can refer to the Spanish if you prefer. I'm looking at the English translation, which is submitted by your counsel. And if you look at the second page of the English translation, the second bullet, which says, Minai does not encourage the expansion of this national park up to 1,000 meters from the public zone. Do you see that?
Yes.
So the minister is not talking about the 75 meters from the public zone. What he's saying here, or what the Ayuda Memoria is saying here, is that Minai does not encourage the expansion up to 1,000 meters. Correct?
That is what this says.
It says nothing about 75 meters, correct?
Correct.
Okay, let's look at the fourth bullet from top. It says, in the private areas declared as a national park in 91 and 95, would like to promote voluntary conservation regime instead of resorting to the respective expropriations. Do you see that text?
Yes, I do.
So let's see what we can make of that. First, it seems the Ayuda Memoria refers to the national park established both under the 91 decree and the 95 decree. Is that correct?
Yes.
And then it says we would like, in that area declared as a national park,
Where does it say that?
same bullet point. Private areas declared as a national park. That would be the 75 meters because the 50 meters are not private areas. It's a public zone, correct?
It's not, doesn't state that here. I don't see any mention of 75 meters here.
I am not saying that there is a mention. I'm saying the reference to private areas cannot be a reference to the 50 meters because the 50 meters is a public zone, correct?
The 50 meters is a public zone, that is correct.
So the reference to public areas must be to something in addition to the 50 meters, correct?
That is correct. I would agree with that statement.
And then they say, we propose an alternative to resorting to respective expropriations, which suggests that unless that alternative happens, there will be respective expropriations of those private areas, correct?
Instead of resorting to respective expropriations.
Right. So doesn't that suggest that Minister Carlos Rodriguez and his staff understood the park under both the decree and the law to be extending inland from the public zone?
Are you asking, is that my understanding, or what my understanding is
You-
of that, of interpreting this?
Mr. Berkowitz, you have testified about this document.
Please ask me the question. I'm just not clear on what it is.
I will. I want to lay the foundation. You have testified about this document. You have stated in your testimony a certain understanding. You are not at the meeting. So what you understood happened at the meeting, you base your testimony on that document. So I'm trying to see what your understanding of that document is. And I'm pointing you to this bullet point, which says there is private property which is obviously not in the 50-meter zone, and it is subject to expropriation under the decree and the law unless a different regime can be put in place. And I'm asking you if that understanding is your understanding of the document.
May I feel free to answer?
Yes, I asked you a question.
Okay. My understanding is I based my understanding of my meeting with the minister
It's not your understanding of the meeting of the minister.
on this
It's
document
your
you're
understanding of the
citing.
document. My question is about, you've testified about the document, you were not at the meeting. We're talking now not about your meeting of the minister, Mr. Berkowitz, but the meeting the minister had with his staff, including the head of department. You have seen this document and you're drawing conclusions in your testimony from this document. So I'm asking about this document and one particular part of it, and I'm suggesting to you what conclusions can be drawn, and I'm asking you to say whether those conclusions are correct or incorrect. I'm not talking about the meeting you had with Minister Rodriguez.
Am I free to speak? I feel that I don't want to do anything improper. Am I free to answer?
Please do. I'd like to avoid this becoming more argumentative than is necessary, but please do, Mr. Berkowitz. Please do.
I just want to, I would just like to speak. In leading up to my understanding of what was forthcoming, the project, which had then become a project of law presented to expand the park by 1,000 meters, was published in the legal document called the Gazeta of Costa Rica. And therein, there was a paragraph that said legal aspects of the project to expand the law, which I spoke to the minister about. This was one of my prime reasons for going in. And it said legal aspects that we're aware that there is no terrestrial component to the Park 7594. We're aware of that. And as such, we want to remedy that. And so I asked Carlos Manuel to help me so I did not spend half my life savings frivolously. And so going into this meeting, they were aware that it had been published in the Gazeta and that they knew that there was no terrestrial fragment to the Park 7594, and this project of law was trying to remedy that. And he stated for the record he was opposed to it. Furthermore, in the next paragraph, he said what he would allow would be a low density, he would allow a low density proper use and management of lighting, green curtain, and use of and implementation, among others. That's exactly what I wanted to do. It was completely conducive to what I planned to do. Exactly, it was completely harmonious with our plans.
Mr. Berkowitz, I think the question that was put to you by Mr. Alexandrov, but I'm not going to put his question other than to clarify my understanding of it, is to seek your views on what you understand by the phrase "in the private areas declared as the national park in 1991 and 1995. What do you understand to be the private areas to be declared as the national park in 1991, 1995?
There were none. There were none. In 1991, it was until paid. Yes, in writing, there was a private area defined, but not until paid. In 95, it was a park that was seaward. And as such, we reached an agreement, informal, that the best way to proceed to save Costa Rica the extreme expense and to protect the turtles was a voluntary regimen of proper development, low density, green curtains, no illumination, which is exactly what we wanted to do.
So what do you understand by the phrase "in the private areas"? You've just suggested that there were no
They were
private areas.
referring to the private areas in the zone of the conflicted zone, the 75 meters. They admitted it was a conflicted zone, and in the project of law, they admitted that there was no terrestrial fragment to the law as written, 7594, and they were trying to correct that.
Mr. Alexandrov?
Thank you, Mr. President. Mr. Berkowitz, hold on to that document, but I want to ask you to look at your second witness statement at tab 5, paragraph 19.
Which paragraph?
I'm sorry, second witness statement
Yes.
behind tab 5, paragraph 19. You say there that the minutes, and I assume you're referring to this Ayuda Memoria, confirm the Minaya position at the time, also communicated to you by Minister Rodriguez, and I quote, that the border of the park was in fact at the limit of the 50-meter public zone, and that the government was not going to pursue the expropriation of privately held properties, etc. So my question is going back to you refer to the minutes for that statement, that the Minaya position was, the park was limited to the 50 meters public zone. And my question is your understanding based on that bullet point number 4 on page 2 or not?
Number 19 on one side and bullet 4 on page 2
Of the
of
English
the
text.
Ayuda? Of the memorial?
Yes, this is the text that we just discussed. I'm looking at the English. In Spanish, it is the third on page 4. En las áreas privadas, you can look at whichever. On the next page, Mr. Berkowitz, in Spanish. En las áreas privadas declaradas como Parque Nacional, en 91 y 95, etc. So my question is, your understanding that Minaya thought the park was limited to the 50 meters public zone is based on this text, correct?
Yes, sir.
Okay, we will move on. Could you look at tab 61, please? This is exhibit R100. Tab 61 is the English. If you want to look at the Spanish, it's behind tab 60. And this is a letter from Minaya of May 7, 2003. So it was just a month before the June 2003 meeting. And it's a letter to the municipality of Santa Cruz, signed by Mr. Carlos Manuel Rodriguez, the minister. Do you see that?
I'm reading it, yes, I
Well,
see it.
let's establish first from whom to whom and the date. Then I'll point you to the text that I want to discuss with you. So can we agree that this is a May 7 letter, May 7, 2003, from Minaya, signed by Minister Carlos Manuel Rodriguez, to the
Yes.
Municipal Council of Santa Cruz?
Yes,
Okay. You can take a look at the letter, but I want to ask you about the first paragraph. And if you see, the end of the first paragraph says, this park and protected zone cover a strip that reaches inland 125 meters from the shoreline at high tide on the aforementioned beaches, in addition to the entirety of El Moro Hill, the hill behind Ventanas Beach, and Isla Verde. Do you see that language?
yes, I do.
Doesn't this letter, signed by Mr. Carlos Manuel Rodriguez to the municipality of Santa Cruz, indicate his understanding and the understanding of Minaya that the park extended 125 meters inland?
According to this letter, that is what he's conveying to Dina Villafuerte.
Okay, and this was a month before the meeting reflected in the Iuda Memoria. Let us continue. Please turn to tab 63. For the record, this is Exhibit R101. The Spanish translation is at 62. At 63, we have the English. So let's first establish what it is. This is a letter signed by Minister Carlos Manuel Rodriguez to the owners of residential homes in Playas Ventanas y Grande. It is to the neighbors, to the residents of Playa Ventanas and Playa Grande. And the date is May 5, 2003. Do you see that?
Yes, I see that.
Okay. Well, let us look. I'm looking at the English, and I'm looking at the beginning of the second paragraph. And let me read it into the record. It says, again, this is addressed to the residents in Playa Grande and Playa Ventanas. And it says, if you are willing to submit to the forestry regime, based on what is set forth in Article 37 of the Organic Environmental Law, you could continue to live indefinitely in the homes you reside in, even though you are within the 75-meter strip that was declared to be the Las Baulas Protected Zone and National Park. So the gist of the letter is, if you submit to a certain regime, you may stay in your homes, even though the minister says they are within the 75-meter strip that was declared to be the Las Baulas Protected Zone and National Park. I submit to you, Mr. Berkowitz, that this letter and the previous document that I showed you clearly state the understanding of Minister Rodriguez in May of 2003 that the 75-meter strip was part of the national park. And I'm asking you, in view of these documents, just a month before your meeting and the meeting reflected in the Iuda Memoria, do you still maintain your testimony that Minister Rodriguez believed that the park did not extend to the 75-meter zone?
I cannot testify what Minister Rodriguez believed. I can only testify what he told me. And I can only testify what you've asked me to testify in the Iuda de Memoria, where it's clear that he wanted everyone in the private lands to submit to a regimen of responsible development, low density, low impact, low illumination. And that was clear in his Iuda de Memoria. I cannot speak to the fact that there is a seeming, again, I have to say, disparity here between what he wrote in May to two different parts and what he communicated to me in May. So there is a disparity. And in June, when his Iuda de Memoria, or July when it came out, there's a disparity between what he's communicating and he communicated to me and these letters, which I've never seen till today. So consequently, when you asked me how did I feel, I said, on a certain level, and pardon my expression, I felt like I'd been bait and switched. I was doing everything I could, very sincerely. I'm a doctor. I wanted to live in harmony with the environment. I served my patients for 20 some odd years. I'm not a monster to destroy the environment. To the contrary, I've always acted in an exemplary fashion in Costa Rica and very respectful of the Costa Rican commitment to the environment and the Costa Rican people. But there is a disparity here, and it's frustrating to me.
It was that disparity that I'm referring to. Please turn to tab 4, which is your first witness statement.
Mr. Alexander, can I just interject for a moment? At some point, I think it's going to be in the best interests of the sanity of everyone and well-being of everyone that we take a brief break. I'm going to leave it up to you, but I think that we should take a break of 10 minutes or so in the course of the next little while. You tell me, I don't want to break the thread of your cross-examination. You tell me when it's going to be convenient.
Absolutely, and I have one more topic, which hopefully will not take long, and then the trade will break in a natural way. So if you could turn to tab 4, your first witness statement, paragraph 7. Where you testify that in early 2003 you purchased a property.
Tab 4.
Tab 4, that is your first witness statement, paragraph 7. We already referred to that paragraph. I'm just coming back to that point.
Yes.
And you testified during the cross-examination that you purchased that property from a company called Corporación Hotelera Playa Tortuga, for a company of which you were the general representative, and that company is called Rancho Ecológico Las Baulas. You remember that testimony and our discussion about that,
Yes.
right? Okay, well, and you also confirmed that that transaction involved all the B properties 1 through 8, correct?
Yes.
Okay. And that was January of 2003, correct?
Correct.
Okay. And Mr. Berkowitz, is it correct that the document reflecting that transaction stated that the properties were inside of the park?
That's incorrect.
Is it correct, Mr. Berkowitz, that the document reflecting that transaction provided that you, as the purchaser, would not have a claim against the seller in case the properties were expropriated in the future?
That is correct.
So coming back to the first question, you said it is incorrect that the document provided that the properties were within the park.
That is an incorrect statement.
Mr. President, at this point, I'd like to make an application to the tribunal. I think it's probably fair to the witness, and I think we can take a break after that. I think it's fair to the witness if I make that application in his absence so that it doesn't taint his testimony.
Mr. Cooper, do you have any comment on that?
I think is my friend renewing his application that was rejected earlier this week?
I think let's proceed on the basis that Mr. Berkowitz is asked to retire for a moment. You can make that application to us then. Mr. Berkowitz, may we excuse you for a brief moment, and then we will immediately take.
If I was asked what it said, I'd be happy to say, but as the question is asked, it's inaccurate. I'm not denying there's verbiage, but as the question is asked, it's inaccurate.
I don't know what Ms. Alexandrov's application is going to be, so.
Okay.
And we will immediately then adjourn for a brief period of 10 minutes and then reconvene.
If I can make the application before that so you can consider it.
Yes, indeed. So, Mr. Berkowitz, we'll excuse you for just for a moment. Thank you.
Mr. President, I didn't answer counsel's question because my answer would have required me to tell you what the application would be. Yes, this is a document that was already at issue, and you ruled that it would not be admissible. I am renewing the application to admit it on a somewhat different ground. Mr. Berkowitz testified about the existence of this document. I asked him two questions about it. One, whether the purchase agreement provided that if there would be an expropriation, the purchaser would have no claim against the seller. He remembered that correctly. He, however, said that it is incorrect that the document said the properties B1 through 8 were inside of the park. I don't submit that he's lying. I would like to refresh this recollection because the document says what it says.
Mr. Alexandrov, before I invite Mr. Copa to make a response, let me just make sure that I and my colleagues understand the position correctly and then put a point to you. So you are renewing your application to introduce into the record the 2003 sales contract, the application that you made earlier on and that we rejected for purposes of the hearing. Is that correct?
That's correct. And I'm renewing this application on a different basis.
I understand that. Let me ask you, in our pre-hearing telephone meeting, which was followed then by the correspondence from the tribunal of April 7th, 2015, we identified in paragraph 19 of that correspondence, which also referred to paragraph 17.3 of procedural order number 1, that we would want to know the reason why the material was not previously produced, the asserted relevance of the material and of its public availability. Why was this material not previously produced?
Because counsel was not aware of this document until 2 days before Friday when the issue came up. We looked for this document in response to a different issue. You'll recall, Mr. President, that claimants sought to update the status of the payments. You know that our position, and I don't want to re-argue it now, you hear arguments about that, is that the purchase price is relevant. And we looked for documents that we thought should be submitted by claimants because those are their contracts. And we found this document. We looked for it then because it became relevant then, at least in our view. We understand the view of claimants that it is not relevant. When we reviewed this document, and we did that for the purposes of establishing the purchase prices for the B1 through 8 properties, which is why we sought to submit it in the first place. But then claimants withdrew their request to submit the other documents. We also read the rest of the document, obviously, hence my questions to Mr. Berkowitz, who has actually testified about this transaction. And the reason I'm seeking leave to submit this document into the record now is because he answered the question relating to the content of this document about which he has testified. And I want to confront is not the right word because, again, I'm not suggesting that he's not telling the truth, but perhaps to refresh his recollection.
I understand that. Let me ask you another question. The respondents and the claimants disagreed about the introduction of this document. In the period prior to that disagreement crystallizing, there was evidently an exchange between the parties in which the parties, in line with the email, I think, from Ms. Cicchetti, indicated that you were seeking to reach agreement and that the claimants had not had sight of that document, and one of the issues that they identified was the hardship being away from their legal base in making an assessment of that document. The respondent evidently chose not to share that document with the claimant. Why not?
Mr. President, we applied that document be admitted into the record in compliance with the tribunal's instructions that the document not be attached. Subsequent to that, there were actually no discussions between counsel before claimant.
That's wrong.
I'm sorry.
Mr. Cope, I'll give you an opportunity to come back.
Can I finish? Between subsequently to that, claimant withdrew their documents.
That still, I don't think, addresses the question of why, when you sought to admit the document and engaging with the claimant, you didn't provide a copy of the document to the claimant rather than to the tribunal, because the injunction against identifying the document is to the tribunal. Why you didn't provide that to the claimant, just as a matter of courtesy, in particular, as in the course of the pre-hearing organizational meeting, and we identified this in the correspondence of April the 7th as well. The tribunal indicated that it was going to be guided by the principle of no surprises. And the tribunal, I should indicate, was struck by the grit that seemed to enter into the exchanges between the parties at around about this time. So I'm wanting to know why there was not simply an accommodation to provide that document to the claimant at that stage.
Mr. President, I may need to consult to reconstruct the whole sequence of events, but my understanding at the time, and that's subject to consultations with my colleagues, is that we applied to the tribunal to admit this document in response to documents that claimants wanted to submit. We assumed at that time that they have it. After all, as we pointed out, Mr. Berkowitz testified about this transaction. It is his document with his name on it, and we assume that it is in the possession of claimants. In fact, as we've argued all along in our written submissions, they should have provided the purchase contracts, and we operated on the basis of that assumption. When we received note that it was difficult for claimants to identify the document before we could react, we understood that they had already withdrawn the request for their documents to be admitted into the record.
They had withdrawn their requests, but you maintained your request. And indeed, it was yesterday morning at the start of the proceedings that you reminded the tribunal of your outstanding requests. So it would still have been the case that with you maintaining your request to introduce the document, it would have been appropriate, I put it no higher than that, to provide a copy of the document to the claimant, would it not?
Mr. President, I don't quite agree. I don't think it is inappropriate that we didn't provide a copy of the document. One, they didn't renew their request after they withdrew their documents, after they withdrew their request to admit their documents. And two, again, after all, it's a document that Mr. Berkowitz has testified about. So he has full knowledge of that document, and he was not sequestered until he took the stand.
Mr. Copa, do you have any observations that you would like to make?
I'll try to be brief. In my submission, the course of action that my friend has taken flies in the face of your procedural orders, your general direction, courtesies between counsel, and notions of fair play. We asked on at least 2 occasions over the weekend while we were preparing for this hearing for my friend to send us the document which he wanted to have admitted. We asked him that first in response to our application, because you'll recall that my response was, we'll try to work it out. They replied and said, essentially, we assume you have it, you're not going to get it from us. They then renewed their application. We noted that we still hadn't received the document. We are now on the 2nd day of the hearing. I still don't have it. I see my friend holding it in various places. That is unsatisfactory, and it's an unsatisfactory way to then try to lift by bootstraps and put to a witness a document that the witness is not in the record, that hasn't been given to his counsel, and then when he has an answer he disagrees with, to say, aha, now I can renew my application. That is, with respect, totally out of order. Now let me say this, and that is the proper approach to this, frankly, for my friend to have done that. He's stuck with the answer. And he's now said, by my count, 3 times, the witness is telling the truth. That means the only reason that the document's coming in is for you to look at the document and draw a different conclusion. He's foreclosed from taking that step. The witness has answered truthfully. The counsel has now said he accepts that answer as truthful. It's not a question of refreshing. It has to be a question of contradiction. And in circumstances where we're still without possession of the document, he's about to try to use in my submission, that ought to be refused. And quite frankly, putting aside any other doubt, when we received your ruling yesterday, if my friend, and I will say this candidly, there's no way my friend didn't plan on pursuing this after getting your ruling. And if he had intended to do that, then he was required to give us any documents he intended to use during cross-examination that he would then seek to enter into. So in my submission, the application should be rejected.
Mr. Copa, I'm not going to entertain the sort of speculations as to what the motivation of counsel for the respondents is. I propose that we proceed in the following fashion. First of all, Mr. Alexandrov, I'd like you to share that document with counsel for claimants. I think it's appropriate that if you're renewing that application that they have sight of that document. So I think the first step is that you should share a copy of that document with counsel for claimants. Second, I'm going to, in just a moment, invite Mr. Berkowitz back in before we adjourn for the break, because I'd like to explain to him that the debate that we're having out of his sight, or out of his hearing, has to do with the introduction of a document, that it doesn't have to do with anything that he has said or done. I think that that's an appropriate reassurance to give him. Third, we're going to adjourn for a period of 15 minutes. And I think everybody needs that adjournment, and the tribunal will then consider the application that you've made, and we'll come back and give you the response after the adjournment. Please do.
Mr. President, very quick points, not necessarily substantive. The record will show I didn't say the witness is telling the truth or not the truth. It's not up to me to say that. I was just saying what was consistent and inconsistent with the document, and I said that in the absence of the witness. So I'm not saying his answers were truthful or not truthful as represented by counsel. The second point is, I don't think it's inappropriate, and speaking of intentions, I don't think it's inappropriate for counsel cross-examining a witness to confront the witness with a document after the witness has given an answer in relation to that document, which may not be consistent with the document. I'm not suggesting I'm planning to impeach Mr. Berkowitz. All I'm saying is when the witness gives an answer and there is a document, even if not in the record, that is different from the answer the witness gives, it is not inappropriate to seek to impeach the credibility of the witness by introducing this new document. And my third point is purely procedural, Mr. President, which is after the break, I'm happy to proceed with my cross-examination on other matters and leave this aside until you determine how you wish to proceed.
Thank you very much. And let me just clarify then in response, Mr. Alexandrov, to the points that you've just made. First of all, we don't take it as any impropriety in putting to a witness a point that arises in respect of his or her testimony. So there is no difficulty there. The issue that arises is in respect of a document that's not in the record, and that's a point that we will consider. We appreciate as well, and the record will show, that you did not make any allegation, nor for that matter any admission in respect of the testimony of Mr. Berkowitz. So we will now invite Mr. Berkowitz to come back in. I will give the brief point of clarification. Juliana, just hold on a moment, please.
I'm sorry, Mr. President, just a point of clarification so that we are operating on the same text. I go back lines 18 to 21. My friend said a few moments ago, I'm not suggesting that he is not telling the truth. And he then says, but perhaps it is to refresh his recollection. My point on that was the introduction of a document after a witness has given an answer to obtain a different answer is a process of confrontation. It's a process of correction. And my point about that was it's seeking to introduce independent evidence other than the answer he's received so far. That's the point I'm making. Yeah.
Mr. Cope, I don't, my colleagues and I will consider this. I don't think that there is any impropriety in going back to a witness, particularly with a document that he may not have directly in mind. Hold on a moment. Mr. Berkowitz has already testified that there are a number of documents which are just being drawn to his attention for the first time. I understand this cross-examination, which has become argumentative, and that's not intended as a criticism, just as an observation, is designed to address questions of appreciation which are of some difficulty because they relate to documents on the record which the witness has not seen, but they also relate to the witness's recollection of a personal meeting that he had with the minister. The line of questioning is entirely appropriate. The only question that arises now is the question of an admission of a document that is not in the record, and that's what we'll reflect upon. So, Juliana, could you bring in Mr. Berkowitz, please? And while Mr. Berkowitz is coming in, just for the court reporters, I note that you are referring to our tribunal secretary, Juliana Kane, as Julian. You may wish to correct that. Sorry, Mr. Berkowitz, I'm going to come to you in just a moment. I've just been asked for, I think there are a number in the room who have their mobile telephones on, and apparently they are ringing and being picked up. So could you please mute your telephones or turn them off? Mr. Berkowitz, thank you very much for excusing us for just a moment, and thank you very much for coming back in. We're going to take a break in just a moment, but I wanted you to come back in before we took this break just to explain to you what's gone on, because I didn't want you to be under any misapprehension. A counsel for the respondent sought to make an application to introduce into the record a document that is not in the record. So it was simply a technical application that he wanted to make, but in your absence, so as not to, as it were, sort of taint your thinking about it either way. He was not making an application in respect of anything that you had said, and I just wanted to give you that reassurance. Okay. Do you want to put the microphone on when you speak? You can repeat. I will repeat that the witness simply responded, "Thank you for that consideration."
Thank you for your consideration.
Thank you. Now, it is now just after 15 minutes past. Let us reconvene. I'm going to suggest a slightly longer break at 35 minutes past 3 o'clock. That's 25 minutes to 4. And Mr. Berkowitz, and also to other claimants in the room and claimants' counsel, let me just say for good order that you are, as we're still in the witness seat. Your declaration remains, as it were, intact. And I would ask you please not to discuss your evidence with your co-claimants or with counsel.
Should I remain here?
You are free to stretch your legs, to do whatever is required for reasons of humanity. We'd just like to have you back in pristine order with the thoughts in your head, not the thoughts in anybody else's head.
Next door to LA Fitness, a few laps and come back.
That's entirely it. So we will reconvene in 16, 17 minutes at 25 to. Thank you very much.